the matter.
Thank you, Presiding Judge. Justice Anderson, Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Barbados, hearing of the application BBACR number 2 of 2022 between James Ricardo Alexander Fields and the state. The members of this morning's panel are Mr. Justice Anderson, Presiding Judge.
Good morning, Counsel.
Mr. Justice Barrow.
Good morning, Counsel.
And Mr. Justice Burgess.
Good morning, Counsel.
May we have the appearances, please? Thank you.
Good morning, Your Honors. This Honorable Court, I'm Andrew Pilgrim, and with me is Marty Garnes, and we appear on behalf of the intended applicant James Ricardo Alexander Fields.
Yes, good morning, Your Honors. I am Neville Watson, and I appear in association with my learned friend, Mr. Rudolph Burnett, and we appear for the respondent.
Okay, thank you very much, Counsel. Welcome. As we are aware, this is a special leave application, and we are aware that the applicant considers that the decision by the Court of Appeal of Barbados raises a risk of a serious miscarriage of justice. And we have read the application and the relevant documents very carefully. We have formulated a preliminary view. Of course, we can be persuaded from that view, a preliminary view that this is an uphill battle for the grant of special leave. But we were interested to have received correspondence from the Office of the Director of Public Prosecutions, which suggested that the office considered that there was a point of law of general public importance involved for which special leave ought to be granted. Now, unlike the application put forward by Mr. Pilgrim, the applicant, which of course details very clearly why they consider there was a risk of a miscarriage of justice. The correspondence from the Office of the DPP did not make clear what precisely was the point of law of general public importance for which special leave ought to be granted. So we wanted to start off by giving the Office of the DPP an opportunity to clarify for us what exactly is this point of law of general importance, which the office considers merits the grant of special leave in this case. Is it Mr. Watson? Will you illuminate for us, please?
Yes, Your Honor. Thank you so much. For quite some time in Barbados, the High Court has been given a direction where the trial judge sees fit, has been given a direction as it relates to lies of a non-defendant witness, lies told by a prosecution witness. And there is a case in Barbados, Mormons Canterbury and the Queen, which specifically treats to that. Not in a major way in my submission, but it says that essentially if the jury recognizes that a witness has deliberately lied, then the jury must be directed that they cannot or they should not accept anything coming from the mouth of that witness. That because that witness lied about one thing, he will lie, or he cannot be trusted to tell the truth about the other matters. That he most likely will lie about the other matters. And that is the direction that has been given over time. But the learned trial judge in the instant case doesn't give that direction. He gives a direction which is on all fours with a direction coming out of the Eastern Caribbean Supreme Court. And I know your honors are not seized of this case, of this authority. I had some time ago, I had served my learned friend, Mr. Andrew Pilgrim, KC, with a physical copy at the court. And it's Nelson and the Queen from the Court of Appeal of British Virgin, of the OECS, sorry. And the judges at the time were Baptiste J.A., Benman J.A., and Carrington J.A. A.G. The reference is ANUH CRAP 15 of 2009.
Well, thank you for the reference, counsel, but I imagine that you would make a copy available to the court in due course.
Indeed, Your Honor, I will. And what I would wish to say, Your Honor, is that the direction that has been given over time appears to me to trespass on the competency of the jury to determine for themselves, to assess and to weigh up where the truth lies in the matter. And to my mind, it aligns and it lives in a symbiotic union with the question of inconsistencies, the question of discrepancies, and the overall tone of the case. To my mind, the direction, if we were to say, do not accept anything that this witness says because he lies about one thing. Suppose for argument's sake, and this is just anecdotally, suppose for argument's sake, that witness said, look, my name is Neville Watson, I live at Portmore Lane, whatever, and that's my address. But then I come along then and I said something that is a lie. It may not even necessarily touch the marrow of the case. It may not necessarily do that. So because that is the case, is the jury, or must the jury be directed, look, if he says one thing that is a lie, you must discard everything. So his name is not Neville Watson. He doesn't live at Portmore Lane. So the jury is not able to assess that. And I think that we run the danger of stepping into the jury's competency.
So at the moment, then it's virtually a rule of law. It's virtually a case where the judge excludes certain evidence from consideration by the jury. All the evidence given by a witness who is found to be lying in one particular. Is that what you say?
Yes, Your Honor. And yes. And I'm thinking, Your Honor, that we really cannot exclude, since the jurors are the supreme, as we know, are the supreme judges of the facts, and any withdrawal of any evidence from their consideration, in my view, my respectful view, is simply a usurpation of their function. And I respectfully say an impermissible usurpation of their function.
Well, there are other categories of evidence which are excluded from consideration by the jury, wouldn't you say?
I quite agree, Your Honor. I quite agree.
In this particular case, though, you are not suggesting that there was the potential for a miscarriage of justice, are you?
No, Your Honor. I'm not suggesting that at all.
Because the Court of Appeal considered this point in extenso, as you well know, and found that it was unlikely that there was a material misdirection, but that even if there was, They prayed in aid, I think it was the Criminal Appeals Act, Section 12, which suggested that when one looked at the totality of the evidence, there was no indication of a miscarriage of justice or that the safety of the conviction was in jeopardy. So I'm just concerned about how you would propose that we go forward, because on the one hand, you're saying, well, there is no risk of a miscarriage of justice here. But on the other hand, you wish us to look at the correctness of the Morban's-Canterbury case.
Your Honor, I quite understand. I quite understand where Your Honor is guiding me, pushing me, so to speak. And what I would say is that this direction has been up in the air, in that some of our High Court judges give it, others do not give it. And what I was looking for, or what I'm looking for, what our department is looking for, is some measure of uniformity going forward, as far as that is concerned.
Thank you, Mr. Watson.
I'm obliged to you.
My colleagues have any questions for you? You're on mute, Justice Barrow.
Appreciate it, thanks. Mr. Watson, if we were to engage with this question or with this matter, what is the area that we would engage with? Is this not hypothetical in this case? So you gave an example, a lovely one. The statement, the misleading or the false statement of a person's address. And you use that to argue that for the judge to tell the jury that because the witness lied about his address, then the witness should be treated as entirely discredited and don't believe a word that he said. And that was, as you say, a very strong example of how far this direction can go. But in this case, what would be the context in which this court could be asked to address this question? The matter of a lying witness was raised in the context of Mr. Carter, was it?
Yes, Your Honor.
And it was a case in relation to Mr. Carter's evidence. Simply, whether you believe Carter when he said that he saw Fields shoot there, or you do not believe. There is not anything else in Carter's evidence for you to not believe or to believe, notwithstanding that you may find that he was lying about who shot there. So I am curious as to how we could engage with this question. I understand the question, but I'm curious as to how we could engage in this case with that question. Help me.
I tried my best, Your Honor. Now, I think that going forward, we are bound to see this ground coming up again. This ground as it relates to directing the jury, if a person lies about one thing, he will lie about another thing. So discard all of this evidence, jettison it. And I do suspect this ground is gonna keep coming back like a haunting motif, so to speak. And perhaps it needs to be put to bed. Since Morban's-Canterbury is really is really what my friends on the other side rely on time and again. And I believe, sir, that perhaps this honorable court, being the apex, being an astute court, perhaps can give us some guidance going forward in that regard. Even though we understand the bedrock of this direction as it relates to lives.
No, Mr. Watson, you need to help me more than that. You need to tell me the context in which we can clarify this matter. Let me take it one step further for you.
Yes, Your Honor.
In relation to the same matter here. Suppose it were being argued in this case that E.A. Fields Whitegrum lied about whether he had gone to the shop to buy a cigarette, and it turned out that he had gone to buy rum. Now that could be very poignant in the context of this case. And therefore, the question as to his credibility, which you would say is entirely a matter for the jury, and the objective circumstances which attended that credibility, these are factors which could weigh very heavily in relation to what would have been the appropriate direction as regards lying in that instance. But this is not what we are dealing with. So unless we were to make up that example, we cannot say that in this instance, A, the direction generally was wrong, was erroneous, or B, we cannot say that even if the direction was erroneous, there was not a miscarriage of justice, etc., etc. So I am trying, I understand the need much more than I did earlier for clarification on this issue for the bar in Barbados, but I am concerned to not get into an academic exercise. So help me.
Your Honor, now that Your Honor has put it like that,
No, I can't speak to that. Thanks.
I would wish Your Honor to piggyback or to tag along, Your Honor, with what you've just said in relation to an academic exercise, and I would wish also to say that perhaps each case would turn on its own merits, on its own circumstances, and then your lordships or your honors would not then see the need or have the need to give us some direction on that point going forward, because each case would turn on its own facts, its own circumstances.
I am sorry, Justice Barham?
No, my brother, please go ahead.
Yes, no, I was wondering in providing the assistance requested by my brother, Mr. Watson, whether the test for special leave as developed by this court might not be useful for us to consider. Because it seems to me that the test of special leave contemplates leave being granted into quite different circumstances. One is where there is a risk that there could be a serious miscarriage of justice, the ground alleged by the applicant. And the second is where there is a genuinely arguable point of law of general importance. And you seem to be suggesting to me that this point that you have raised about how to treat with a witness who is lying is a point of law of general public importance. And the test suggests that in those circumstances, the function of this court is to assist in the clarification of the law so that we don't have a dubious precedent remaining on the record. Is that not the kind of assistance perhaps that my brother might benefit from?
I crave your indulgence, Your Honor. I'm grateful for your indulgence, Your Honor. Your Honor is right on that point.
Yes, my brother Justice Burgess.
Yeah, sorry, but isn't there a problem still remaining? The problem is that the application for special leave is made by the appellant here, the intended appellant here, and the criteria which my brother spoke of, does that relate to an intervention by the DPP, or does it relate to what is open to the intended appellant?
What is open
in other words, is it open to the DPP to assert public interest in the terms adumbrated by my brother chairman? Is it open to the DPP to intervene in that way?
I as the Chief Minister of Justice, sir, I would think so. That is open to the DPP to at least carry the flag of justice, to make sure that it is flown properly, and to make sure that we don't have any of these situations arising time and again.
But aren't there procedures in the Criminal Appeals Amendment Act which provide for the DPP in given circumstances to raise those kinds of matters before the appeal and then forward to this court?
Yes, Your Honor. The DPP is well in a position to seek a reference.
I'm not certain that I'm not certain the act gives that opportunity on this occasion, but I would really still like to hear you a little bit more expansively on the point made by my brother chairman, and whether that is not a ground which is open to only to the intended appellant. Because because as my brother Barrow is pointing out, you're taking us into new places, and we want to be certain that we're going there permissibly.
Yes, Your Honor. If we look at the rules and the leave, the application for special leave, and we consider the issue of miscarriage of justice, a serious miscarriage of justice, then building on what Your Honor, Mr. Justice Barrow said about the grave indulgence. Yes, sir. About what what Your Honor, Mr. Justice Barrow said, as it relates to the example that I made, the name of the person, the name of the witness, etc., and then the lie in relation to some other point. then this is just simply a matter of credibility. And it is one that is within the competence of the jury and not necessarily one that points us in the direction of a serious miscarriage of justice. It is one that can be cured by a direction that's given by the learned trial judge in the Easter case, and indeed in the case of Nelson and the Queen that I made a reference to. So that being a question of credibility and being a question that can be cured by a direction, a proper direction, which is within the bosom of the trial judge, then unless that direction is flawed, seriously flawed, then there is no miscarriage of justice, and it does not bring us to the point where we can say special leave is granted or special leave ought to be granted. I don't know if that is that. I don't know if that answers the question.
So Watson, may I ask in relation to your case of Nelson? Obviously, the Court of Appeal did not discuss Nelson.
No, Your Honor.
So the question is this: has this case, which obviously is part of your armory, has this case been discussed by any court in Barbados? You tell us that different judges apply Scantlebury or not, but I am curious as to what is the jurisprudence in Barbados in relation to that aspect of the matter.
Oh, very well, sir. Nelson, the case of Nelson and the Queen, I only got my hands on it just about a month ago. I just got my hands on it quite recently. Because I've been searching uphill and down ditch for authorities in relation to this same point. But on the second point, the courts in Barbados, they rely on Scantlebury and the Queen. This case has never been canvassed. It's never been canvassed at the Court of Appeal level in Barbados. It has never been raised even at the High Court level, because we never had sight of it before. At least I never had sight of it before. My department never had sight of it before. I shared it with my learned friend, Mr. Andrew Pilgrim, KC, and I am not certain whether he had sight of it before.
Well, no doubt we'll hear from Mr. Pilgrim shortly. But in relation to your difficulty, I hope I'm not mischaracterizing the situation. In responding to my brother, Justice Burgess, is it not the case that the question of how to treat a witness who is lying on the oath is itself raised in the application? Is not one of the grounds of the application? I seem to see that Mr. Pilgrim, who of course appeared in Scantlebury, raises that as one of the grounds of the application. So do you have the difficulty that you seem to think you have in relation to this ground? In other words, is it not already before the court in the form of the application made by the applicant?
Yes, Your Honor.
Thank you.
But even if that is so, wouldn't we have to benefit from a discussion of the issue in the Court of Appeal? Because as my brother Barrow pointed out, was the case argued before the Court of Appeal? Was the OECS case argued before the Court of Appeal? And is that case binding in Barbados? Doesn't the doctrine of stare decisis say that the Court of Appeal in Barbados binds courts below it except this court?
Yes, Your Honor.
So wouldn't the Court of Appeal have to pronounce on the authority of Nelson? Is the case you referred us to? Would it have to make a pronouncement in respect of Nelson, which this court would then consider?
Your Honor, Nelson was not before the Court of Appeal.
But that's precisely the point. Counsel, that's precisely the point. Can this court leapfrog the Court of Appeal in respect of this matter, which is of public importance?
I wouldn't think so, sir.
All right. Anything further?
I think Mr. Watson has rendered all the help he can to Mr. Pilgrim so far, Chair, and I would not detain him any further.
And I see Mr. Justice Burgess is similarly generous. So can we then move to Mr. Pilgrim, who I would be very happy if you could confirm my suspicion that you were front and center in Canterbury and that you're very familiar with the point that we are discussing this morning. And of course, more generally, to seek to overcome our preliminary view that this is not a case representing a risk of a serious miscarriage of justice. Over to you, Mr. Pilgrim.
Obliged to you, Your Honor. Your Honor, first of all, I think while I understand everything that my learned friend has said, and we haven't had the benefit of it in the form of a formal submission, I think we here in Barbados are all agreed that Scantlebury is the law and has been the law up to this point. I think it is also a genuine concern, and I hope I'm not taking tales out of school, to say that one judge, and that's the judge, the trial judge in this case, is not applying Scantlebury. And we say that the results of that are disastrous. And we say that the Court of Appeal is not acknowledging that as a formal error in this particular decision. In other words, we are saying the Court of Appeal is failing to apply Scantlebury. And they're referring to discrepancies and inconsistencies as a way of justifying what we say is a straight misdirection in law. So the first point is that we are agreed with this court, I think, that there is a serious point of law which merits discussion. As it applies to this particular case, this is a case, and I thought it opportune that Justice of Appeal Barrow made the reference to ESA Fields, because this is a case in which the primary witness for the state is a fellow known as Drunkard. And the quality of his evidence, I think, was always going to be under scrutiny. And because that person's evidence is the sole evidence that sits between the liberty and the incarceration of James Fields, it is our view that there was scope and is scope for a court to find that there could have been a serious, because his credibility, we say, was always in doubt. And that the Court of Appeal did not accept, for example, that his description of how the incident took place physically, that the Court of Appeal did not take that seriously as a major inconsistency, that his ability to identify on the parade, a parade on which there were people who could not possibly have been fitting anywhere near to the description of the appellant, that those issues are serious issues that could have led to a serious miscarriage of justice. But moreover, the Court of Appeal is saying that I did not point to a particular lie that was told by the witness. And my understanding of the law is that the law is, if the jury believe the person to be lying, the jury are obliged to disregard that person's evidence. I never understood that there would have been an obligation, therefore, on counsel in the Court of Appeal to say, if the jury believed that the witness was lying when he spoke about his address, for example, or when he spoke about how much rum he drank on the day, or when he spoke about this or that, that there was any obligation on counsel to say, this is the lie I mean, and this is the lie that could lead to a miscarriage. On the contrary, I thought it was the jury who would say, we determined that this man is lying about X or Y. And being told that, understanding the law as it is in Barbados, would be entitled to find that this person was a liar. And that if they were a liar on anything, our law says deliberate lies warrant a particular response. And that response ought to be that that person's evidence should be disregarded in its entirety. Now, I think, I am of the view that my learned friend, Mr. Watson, sees and knows this in respect of this particular case, and is aware of, one, the danger of a miscarriage, notwithstanding that the Court of Appeal doesn't agree with me, but that, and he's also aware that there's a major legal point that we ought to have this court's guidance on. And so that I am, notwithstanding the court's position as I understand it so far, I am loath to resile from the position that this was a case in which there was a genuine danger of a miscarriage. Now, my lads, I don't like to, your lordships, I don't like to, your honors, I beg your pardon, I don't like to beg off and curry favor on the fact that my brief is not as full as I would like it to be, but it is not. But suffice it to say that Scantlebury is not the only case in Barbados in which this law is clearly stated to be the law. And there are some other cases that we would have wanted to include a brief, but we have not. As opposed to Nelson, which we say is just, essentially at this stage, we say irrelevant. In particular, there's the case of Glyne Cumberbatch and the Queen, and Seal against the Queen. And I would furnish the court with copies of these appropriately if the court has need of them. But suffice it to say that it's our view that Scantlebury is the law, and that what is happening now is that we're running into a dangerous position where the Court of Appeal is skirting. Now, it may be, and I think my friend will bear me out in this, that they may have an opportunity again because the same judge is doing the same thing again in other cases that are now in the tube and coming your way. But I think, like my friend, I'm of the view that if this can be addressed now, it is better addressed now than later, when it is, this Barbados is in the unique position, I think the court may know, in which we're actually working. Whereas we had a period there of maybe a decade in which cases were not being done. Mr. Watson and Mr. Burnett will bear me out in the fact that our courts, at least 7 of them, are working every day and doing sessions work, doing high court trials every single day. So that the longer this problem remains outstanding with one judge, I don't want to call him a rogue judge, giving a particular set of directions on a particular point, and all the other judges appearing to give the other direction, which we say is the law, on another point, we are going to run ourselves into difficulties. And so that, to the extent that this court would accept that either A, there is a possibility of a miscarriage, as I say, or B, that notwithstanding the fact that I don't plead that in my pleadings, that this court ought to find that there is a matter of great legal importance which this court ought to pronounce on, whether as raised by my friend or as orally amended by me here now. Either way, I'm of the view that this court ought to hear at least that point, as opposed to letting it remain. And this is not criticism of, I use the term rogue very loosely, and perhaps I apologize for the use of that term, because I don't want to suggest that the judge is doing anything wicked or wrong or bad.
Yeah, we accept the correction.
Obliged to, Your Honor. The judge is saying this is his view of the law. And he is saying over and over again, to his credit, that he does not agree with Scantlebury. He's saying that openly. But the challenge is that he's the only person saying it. He is also, I think it's fair to say, the hardest working judge. So that the challenge will be that we're going to get a rapid buildup of these cases going in 2 different directions. And for that reason, it is, as my friend says quite openly, an extremely important point for us all. But my underpinning to that is that in every case in which you hinge your conviction on one witness, whose credibility is on its face, not just because of his nickname, but on its face, the whole basis of the defense. The defense is saying, this man is not to be believed. This man is not to be believed. And to have the Court of Appeal say, notwithstanding a direction that goes directly to the issue of credibility, possibly being wrong and skirting it by saying it could be that he's not saying that where a man is deliberately lying, you should disregard, but he's actually talking about its inconsistencies. And it seems to me that where we are now, we are avoiding dealing with an elephant in the room, and that the elephant needs to be addressed, and that this court ought to grasp the opportunity with both hands to deal with it as sooner rather than later. As I say, I know it's going to come, but I think sooner is better than later.
Well, with that, thank you very much for that very forthright presentation, Mr. Pilgrim. I think for me, anyway, that's very, very useful. And without disrespect to the other grounds raised in your application, and we have studied all of the grounds very closely, I do think that this is the most intriguing and interesting one, so that we obviously will consider what you have said. I don't know if my brothers wish to question you.
Yes, I would.
Sorry, there's just one matter on which I'd like to hear Mr. Pilgrim. Should this court, without having the views of the Court of Appeal, the views of the Court of Appeal directed to this issue, should this court undertake to settle the matter?
But Your Honor, as this point was argued in the Court of Appeal, it's just that Nelson was not cited to them by the defense. And I suppose in fairness to them, I could say we did not rely on Cumberbatch and Seal, which I referred to earlier, but this point was canvassed, and they're saying that there's a way around it. It's our position that the Court of Appeal, and I think that my friend agrees with me, my learned friend for the defense agrees, for the respondents agree that the Court of Appeal has not dealt with this frontally, whether this is a misdirection or not, and what ought to be the impact where there is one witness whose credibility is in question.
Yes, it's just that I would be comforted to know that the various authorities were cited to the Court of Appeal, and that the Court of Appeal had a chance to pronounce on it before.
Scantlebury was quoted to them.
Sorry, could you repeat that? I'm not hearing you.
Sorry, Your Honor, Scantlebury was quoted and argued.
Yes, that's Scantlebury.
Was argued in the same way before them, and we're saying that they got it wrong.
Yeah,
Scantlebury but was the fullness of the matter discussed before the Court of Appeal?
Yes, Your Honor.
Okay.
As I said, I think our feeling that we didn't have.
Repeat?
Sorry, Your Honor. I was just saying that the only failing that we could admit to is that Seal and Cumberbatch were not canvassed to say it is not just Scantlebury. There are other cases saying exactly this. This is the law. There is no doubt. We were of the view that Scantlebury was sufficient, that we could just hold up Scantlebury and everybody say, oh yes, this is the law, and we're agreed. But they did not agree. But subsequent to that, we have found Seal and Cumberbatch, which we say make it clear that Scantlebury was in fact the law and is being applied across the board by the Court of Appeal.
Mr. Pilgrim, you said in your submissions that Carter is the sole evidence standing between your client and essentially his freedom. And yes. I found it startling. The confession that he gave, is that not in itself sufficient to convict him?
I think there is a view, Your Honor, that confession could be relied on by the state, but our view is that confession also contains defenses.
No, sorry. One can argue, the defense could argue that in the confession, there is a potential defense, perhaps mitigation, whatever, but that's not the point. The point is, you said that Carter's evidence essentially was the only evidence upon which feels was convicted. And it seems to me that the judge gave a lovely disquisition as to the Kamal Brathwaite prowess of Mr. Fields in writing that confession, etc. So that even if you were to disregard Carter, I do not see how you can get away from the impact of that confession as a basis for the jury to have convicted him. Help me with that.
In my view, Malad, that confession can be interpreted in one of three ways. So it's but I think
but
that
one of the ways in which it could be interpreted, and I understand reasonable doubt, etc., which was explained to the jury by the judge, etc. One, and the central way, the one which occurred to me, was that he said he shot the man.
But in circumstances that have to bear in mind, Your Honor, that this is a conviction for manslaughter.
Yes.
So that this is in which you have to then assume that the jury were going on what, provocation or less than serious harm,
right,
as opposed to defending oneself. So
yeah.
In my view, that Carter's evidence would still be extremely important in this case in terms of their ability to convict. Is all I'm saying. I don't think that the confession makes the state home, takes them home free.
I hear you.
Oblige, Your Honor.
Thank you. So if I may summarize then, I think both sides agree that there is a point of law of general importance which should be decided by this court on the grant of special leave in this case. And we have discussed for almost the better part of an hour what that point is. Of course, we are not in a position just yet. If we were to go in the direction of granting special leave, we would, of course, have the submissions of the parties in that regard. But we are grateful that there is unanimity on both sides on this question. Of course, as we know, the grant of special leave is always discretionary. And even if both sides agree, as they seem to in this case, it may be that the court considers that this is not an appropriate case for the grant of special leave. So what I propose that we do now is to take a break, and the panel will deliberate. And as soon as we have a decision, we'll come back to you.
I'm obliged to
Thank
report.
you.
We in Barbados are not accustomed to prompt decisions, so it always takes us a little bit off guard, but we're with you, sir.
I am not making any guarantees about the promptitude of our decision. I said we are going to deliberate and then see what happens.
We're entirely in your hands, sir.
Thank you. Be airlifted from this platform and placed somewhere else.
Court resumes, Judge. Thank you.
Thank you, Deputy Registrar. And thank you, Counsel, as well, for your significant assistance to the court. We have considered the matter and we have agreed to allow the application for special leave. The application will be restricted to the ground that we have been discussing this morning, namely the Scanterbury ground, for want of more expansive words. And we will, of course, very shortly be issuing an order which will indicate the period of time for the filing, serving of the notice of appeal and the submissions which will follow. We want to make the point, though, that we would like to hear this matter urgently, not least of all because of the points made by Mr. Pilgrim, the need to clarify the situation for the judiciary in Barbados. So we are hoping that we can hear this matter, as I said, fairly urgently. And we are thinking of June as sort of the date or outside date that we can hear this. So we're hoping for fullest cooperation from counsel on this point. Is there anything else, counsel, that you wish to raise?
Your Honor, I think it's sufficiently important that we ought to put things aside as necessary to make sure that we can hear it when it's most convenient to the court. So from that point of view, we definitely agree. We felt quite hamstrung, and I was adverting to it obliquely during my submission, because in this case we received the decision orally on X date and received the written copy, I think 4.5 weeks thereafter, which put us in a very difficult position to meet your deadline in terms of our obligations to file on time. So the submission, even when as we're reading it here today, I'm not happy that it is our best work, in the sense that we did not have our full opportunity to put time into it, and now we will make the time accordingly to ensure, because we don't have the exclusive decision late at this level.
Wonderful, we appreciate that. Mr. Watson?
I have nothing to add, Your Honor.
Well, thank you both very much, and we look forward to further engagement as we progress this issue. Madam Deputy Registrar, would you please close the proceedings?
Thank you, Mr. Justice Anderson. Thank you, Mr. Justice Barrow. Thank you, Mr. Justice Burgess. Thank you, Counsel, and thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.